Hi, it's Shan Wu with a Under Color of Law hot take on another Supreme Court shadow docket case. Remember, we were just talking about how there's going to be more of these cases likely because there's a whole fast and furious flurry of cases being brought by Republicans mostly to suppress voters and suppress the vote. And they're all kind of like heading up towards the Supreme Court, mostly in the form of stays and such. So there was another one which the court just issued, which is about the Pennsylvania case. And this was a case where the Republicans wanted to stop voters from being able to cast their provisional ballots. Why? Well, the particular voter, I think there are two voters at issue there, they forgot to wrap their mail-in ballots in the so-called privacy envelope. There's like an envelope within the envelope. And that was an error. And then they wanted to be able to cast the provisional ballots. Republicans didn't want that to happen. So they were defective mail-in ballots. And the Pennsylvania Supreme Court quite logically said, that's okay. Let them send in their provisional ballots. Let people correct these sorts of errors. And the Republicans wanted to challenge that. So the United States Supreme Court has rejected the Republican effort to stop this. So they're letting the Pennsylvania decision stand. So those sorts of remedies of defective ballots can be counted. What's curious about this is it's a shadow docket because, as we recall, the shadow docket really is meant to deal with quick orders and such. And oftentimes it's just an order. It gives the outcome without any opinions, dissenting opinions, or any other kind of reasoning to it. In this case, Justice Alito, joined by Gorsuch and Thomas, put out a, quote, statement. It's not a dissent. It's just a statement that he wants to send to the public. So we're going to put the statement up for you. It's pretty short. And I'm actually going to read it just so I have something to comment on. It'll be fresh in my mind, too, as we read it together. And, well, I'll save my commentary for afterwards. So I'll paraphrase some of this. The application for stay is presented, and then he describes it as saying, the case concerns a recent decision of the Supreme Court of Pennsylvania that adopted a controversial interpretation of important provisions of the Pennsylvania Election Code. Specifically, the court held that a provisional ballot must be counted even if the voter previously submitted an invalid mail-in ballot within the time required by law. The applicants, meaning the Republicans, contend that this interpretation flouts the plain meaning of the state election code and that the interpretation is so far afield that it also violates the Elections Clause and the Electors Clause of the Constitution of the United States. Cites the articles as well as Moore v. Harper. Seeking to prevent county election boards from following that interpretation in next week's election, the applicants, the Republicans, ask us to stay the state Supreme Court's judgment, or at least to order the sequestration of ballots that may be affected by that interpretation. The application of the state Supreme Court's interpretation in the upcoming election is a matter of considerable importance. But even if we agreed with the applicants' federal constitutional argument, parentheses, a question on which I express no view at this time, we could not prevent the consequences they fear. The lower court's judgment concerns just 2 votes in the long-completed Pennsylvania primary. Staying that judgment would not impose any binding obligation on any of the Pennsylvania officials who are responsible for the conduct of this year's election. And because the only state election officials who are parties in this case are the members of the Board of Elections in one small county, we cannot order other election boards to sequester affected ballots. For these reasons, I agree with the order denying the application. Now, English is my first language, folks, but I find that to be kind of gibberish. What is he really saying? He's saying, look, I'm not going to comment on the merits of this constitutional question, but I'm going to say all these other things to you. So what's it sound like he's saying? It sounds like Alito's saying, look, this is such an unimportant case that I'm not really going to make a big deal out of it. It only concerns 2 voters. It only concerns 1 county, so it could have no effect upon the rest of Pennsylvania. So therefore, I'm going to agree that we don't need to do anything. Now, I say that's gibberish. I'm trying to make it clear. I had to read it several times, and I'm thinking, what is he really up to here? How can it be that unimportant of a case when potentially thousands of voters could be affected by the same ruling here if they'd gone the other way? He seems to be saying, no, we only would have been ruling on this one county. That's kind of not what a lot of the reporting understood it to be. That's not what people were waiting on this for with bated breath. It's not what the Republicans thought. Otherwise, why even bother trying to challenge it? So, reading really between the lines here, take a look at the case he references, Moore v. Harper. And Moore v. Harper, just to remind us of what that was, I'll put up a piece I wrote about a while back. Moore v. Harper, before it was argued, was considered to be kind of like the Darth Vader of cases coming up. It was an attempt to resurrect the previously dead independent state legislature theory, the ISLT theory, which basically could have resulted in the state legislatures being able to really just go their own way with the election results. That case, as I'd written, was so controversial that more than 70 amicus briefs, friends of the court briefs, were submitted. Everyone from former California Governor Arnold Schwarzenegger to the ACLU, all were saying this was a really bad idea. Now, thankfully, the Supreme Court rejected that theory in Moore v. Harper. Alito dissented, along with, guess who? Gorsuch and Thomas. Now, why then is this surfacing in this sort of throwaway aspect of the statement by Alito? Well, in the rejection of Moore v. Harper, you can say that that is pretty much dead. But it did leave room for courts to be weighing in and to look at, and state legislatures to weigh in, if there's something really extreme about what's happening. It kind of left this tiny window there, as the Brennan Center points out. I think that's something Alito could be hinting at, which is he's trying to send up a message to the Maga world, to the Republican potential challenges. Look, I'm aware that Moore v. Harper left some space for us to weigh in. Maybe I'm even suggesting I think Moore v. Harper could still apply in these extremely limited situations. Otherwise, why is he bothering to make this statement? Now, there are some folks, I'll put up this little thread from Ellie Mistal, who thinks that that could be some of the mischief that the Republicans will be up to, which is trying to get back to the Supreme Court so they can use this small kind of window or small exception that might remain of the Moore v. Harper idea. But, you know, it doesn't even have to be resurrected. As, again, the Brennan Center points out, I'll put up that link or screenshot for you. You know, it's been 10 years since the Shelby case really gutted DOJ's ability to pre-clear state changes and therefore safeguard bad efforts by states to hurt voter turnout, to suppress voters, to make things unfair. But in that time, I mean, as soon as that case came down, tons of these restrictions began to come up. It's a question now for DOJ of having limited tools. They have limited legal tools because of Shelby, but there are also prudential reasons that they may not want to weigh in. There's a sense with DOJ that they don't want to be seen as becoming involved in the case. They certainly wouldn't want the sight of federal marshals, FBI agents at polling places to watch out for things. So when you combine those, this gets to the question a lot of us have been asking, which is, with all these sorts of threats, with all these challenges, why doesn't DOJ weigh in more often? That's really one of the reasons. Legally and from a prudential perspective, they feel they may lack the ability legally, the jurisdiction, and they're worried about the way that it looks. The time for them to weigh in, of course, is way before you're having a problem at the ballot box. I mean, I've said before, I think there's a lot of things they could have done much earlier in this process to cut down on some of the attempts at abuse that are being made. But that's the bottom line right now. So we're going to see a lot of these cases popping up, probably see some more shadow docket issues as well. And you're not going to see DOJ jumping in on a lot of these things. And you're certainly not going to see them really doing something the day of voting. And those are the reasons for it. So fingers crossed, won't really have anything really bad on those days. But just wanted to give you a sense of, again, some of these issues that are popping up very, very quickly right now. So good talking to you. Hope you will subscribe to the channel and give me a follow on Twitter and keep those replies and comments coming. I really like hearing from you. Thanks.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.